Fast forward again to 17th and 18th century France. In that still very Catholic society, despite the directions very small elite minorities in Paris and other cities were going by then in France, criminal cases were regularly, if not frequently, brought against clergymen by lay accusers in secular courts, not only through the ecclesiastical court system. And there it was considered unremarkable, indeed consistent with good order and the spiritual well-being of the whole Catholic community, that if a priest violated a member of the laity, lay accusers, lawyers, and judges had some customary rights to pursue justice. Thus, in 1727, for example, a parish pastor in Provence was convicted and hanged by secular authorities for his crime, note this, of spiritual incest with a young woman in his parish whom he had seduced. In 1731, the highest level secular court in Aix-en-Provence tried a prominent Jesuit for the same crime. I believe the Jesuits slipped away, as they sometimes do. He was tried for the same crime, spiritual incest, with a laywoman with whom he had a confessor-penitent relationship. Now, in that deeply Catholic society, secular authorities didn't speak of, quote, consensual sexual relationships between adults, unquote, when one party was a priest and the other, however old, was under his spiritually paternal care. In 1757, likewise, the curé of Loudres in Lorraine was sentenced by secular lay authorities to be burned at the stake for sexual misconduct with a young man. And in 1783, a Capuchin monk who had sexually assaulted and stabbed, not to death, a young 14-year-old boy, was tried and executed by secular authorities in Paris by being broken on a wheel and burned alive in public. Although he could have asserted clerical immunity to be tried first in an ecclesiastical court, no churchman emboldened him to do so, apparently because they didn't wish to seem to be going out of their way to protect clerics guilty of pederasty.